Good morning. Welcome to Sunday Symposium. Like seeing you all here. It's going to be a beautiful fall afternoon like yesterday. Wasn't that great? You guys been getting out walking or doing anything out here? It's been spectacular this fall. I think as soon as the fire danger went away, everybody went out and started having a really good time. So welcome to Sunday Symposium. You might see we have a little bit of a switch up today. Robin, who was going to do big cats for us, is unfortunately ill and will not be able to make it today. And we are rescheduling for next year. Okay, so instead, we're going to have a little changeover in program. And we hope you'll enjoy George doing marriage in America. Okay, so if I may ask, if you will please put your phones on mute or what the heck, turn them off. I bet they haven't been turned off in a long time. Okay. I was on the Sunday Symposium board prior to this and worked with George, and actually first met George, I believe, really at a Sunday Symposium when you were speaking on one of the incredible topics that you gave a speech on. And then I would run into George all over in Oakmont at the fitness club where he and his wife were quite faithful. I don't know what's been going on since COVID, George, but I miss not seeing you there. Less. This is okay. And George moved here to Oakmont in 2002 with his wife. And if you have been involved in almost anything in Oakmont, you've probably run into George. How many people here know George already from, yeah, that's what I thought. Okay, everybody knows George. Did you know that? Everybody knows you. Okay. He moved here to Oakmont 2002. He has been heading up the genealogy. He's been in Great Decisions, OLTC, that's our learning center, our fitness club, OEPC and COPE, long range planning. I know you've done more than that, George, but that's all he gave me for his bio. And when we found out that Robin was not able to attend today, George graciously not only stood up to do a speech, but actually got it together within a couple days for us today. And we want to welcome you back, give you a big welcome to the Sunday Symposium. And this must be what, your fifth talk for the symposium. Thanks so much, George, for coming and helping us.
Okay. Let me get this thing started. Okay, let me start off by saying if there's anybody who feels that they don't want to hang around for this because they came to see the cute little lion cubs, you are more than welcome to leave and I will not be embarrassed. However, we are hoping that Robin will be feeling better soon and that we'll be scheduling her for the spring to come back and actually do the lions. So we're going to focus today on women's rights particularly. As they relate to marriage. And really marriage over the 400 years of America's history, which has gone from a situation that was reasonably, let us say, not terribly favorable to women who were married, but that was because of British law being brought over here, to worse after the revolution, okay, to gradually getting better. And then in our lifetimes, where we have seen a dramatic change in marriage as it's related to people who were never allowed to marry over the other history of the country, and particularly miscegenation and gay marriage. Okay. So, as a diversion, this was the most famous marriage in the 19th century in the world. Queen Victoria marrying Prince Albert. Hands down, no question. So homework assignment for this particular lecture is when we finish, I'll ask you if anybody knows what the most famous marriage in America was in the 19th century. Okay, and it doesn't, there may be someone who's heard this before, in which case you don't get to answer it. Okay. In fact, this is much closer. Come on. There we go. This is much closer to what a wedding would have looked like in America in the 19th century. We were a rural country. Not a lot of people lived in the big cities. A wedding would have taken place in a home, private residence typically, and it would have been typically the home of the bride. Okay, and it would have been the bride and the groom, a local minister who would have come in to perform the ceremony, and family and friends and neighbors who would have observed. Now, after the ceremony, the minister would have signed a document which he would have sent to the county courthouse. And that document would have affirmed that that marriage took place. So here in one picture, we have the three elements of marriage: community recognition, religious rite, and the administrative legal system recognizing the marriage. Those are the three keys as we go through this to what we think of as marriage. Which means I couldn't resist putting this picture in. This is a watercolor done by my Aunt Ollie. Ollie was the little girl in the front. My great-grandfather was, in fact, a circuit riding Methodist minister, and he regularly performed marriages. He lived up a 2-mile dirt road from the main road, and one day, while he was coming down with his son and granddaughter, they met a couple coming up to get married. And so he just stopped right there in the middle of the road and said, okay, we'll do the ceremony here, which he did. So that's one of my favorite memories of Sam. So we'll start about English common law. It's important to remember that we were founded as a set of British colonies. So most of our history comes from Britain. And there is a concept we'll talk about a fair amount in the next few minutes. It's called unity of person. It also goes into the term coverture, and it refers to what happens to the two parties after a marriage in a legal sense. There were some differences between the colonies, and we'll talk about those briefly. And there were some changes after the Revolution. We will then segue into common law marriage, or what was called self-marriage, divorce, self-divorce, remarriage, bigamy, fascinating little topics, and then the marriages that weren't allowed. So under English common law, the idea was marriage was a contract. Two parties entered into a contract by mutual consent. We are not a society that was built on the idea that your parents would pick you a bride or whatever, okay? That it was lifelong. It was intended to be faithful, intended to be monogamous, okay, which actually is one of the interesting problems we ran into with the state of Utah, which is the state of Utah for most of its history after it would have qualified to be a state, still recognized polygamy. And when finally it was made clear to them that they weren't going to become a state until they stopped, suddenly the elders of the church had an insight that God did not in fact support polygamy anymore. And Christian. And by Christian, think of the English Christian. So we're talking here Church of England. We're talking Episcopal, not Catholic. Okay. So here's a good start. This, in many ways, is the most famous American marriage today, going back into the 18th century. Okay. This is Martha Dandridge Custis marrying George Washington. Those of you who remember Martha's history, her first husband died, leaving her with 2 young children. He also left her with 17,500 acres of land and 300 slaves. Her total value in today's dollars would be over $10 million. She was one of the wealthiest plantation owners in the colonies. Okay, for 2 years, she, as the widow, ran those plantations. They made money. They were viewed to be very well run. Then she married Washington. She lost every legal right she had. She could not do anything with her own property, slaves, the land. He could have been a profligate. He could have gotten rid of all the slaves and used it to drink his way to whatever. She had no control of her own children. Washington's stepchildren, if they wanted to get married before they were of age, he was the one who gave permission, not Martha. Indeed, the problem with the slaves is one of the things that created a problem in the history of and the reputation of Washington, because he was a responsible person and he took fiduciary responsibility for his stepchildren's property, those 300 slaves. That was one of the reasons he could not free those slaves. You follow? Because they were his responsibility to protect the value that belonged to his stepchildren. So the concept of unity of person and coverture we'll talk about just a heck in a moment. And within coverture, we'll talk about dower rights, which is a particular situation. What was important in English law was there was a strong distinction between the roles of husband and wife. The husband, family head, economic provider, the wife, dependent partner. Now, before I go into that more, I want to show 2 graphs. Don't want to dwell on them, but I think they're very important to understand. This graph shows the fertility for women born in particular years. So if a woman was born in 1800, the average woman over her lifetime would have 7 children.
Wow.
Today, that number is a little below 2. Okay, so we're not quite at the reproduction rate. Okay. But so when you think about decisions and the way households were run and everything else, the average woman had 7 children. And this is the number of child deaths per 1,000 live births. In 1800, it was just short of half. Never made it to the age of 5. So this is the world these people were living in. And one of the things that you have to think about when you think about the role of the woman in a marriage in this period is the importance of sanitation, somebody who could care for the house. Keeping the family alive was literally a major job, and you had a large family. This is worth reading because this is the heart of the English law that's relevant. By marriage, the husband and wife are one person in the law. That is, the very being or legal existence of the woman is suspended during the marriage, is incorporated and consolidated into that of her husband, under whose wing, protection, and cover she performs everything, and her condition is called her coverture. So, and Blackstone, for those who aren't familiar, was the jurist who codified. British law was predominantly based on precedent, and he codified the precedent to a series of things that you could look back on and say, oh yeah, that's what the law is. So this is the nature of the world that we grew up in as a country. So let's go to another person we know well. Abigail Smith married John Adams in 1744. She was 20. He was 29. For those who have read their histories, she ran their farm for most of the time that that he was abroad often. Her will listed many different things she wanted to do for people, but she had supported literally a dozen of the female relatives she had who had not married well. So she provided them with money and goods to help them. So in her will, she laid out in great length what would happen with her property to each of these people and what she wanted as bequests financially to them. Unfortunately, she died 3 years before her husband. Therefore, Her will was not found until years later when somebody going through the Adams papers found her will, because it had no legal standing when she died because she was under coverture. She had no rights. John died 3 years later. To the best of our knowledge, he did not follow very much that was in her will. So we have the concept first of a femme sole, an unmarried woman or widow who had a right to own property and enter into contracts in her own name, as opposed to a femme covert. Again, this coverture concept. She did not have any legal rights or obligations distinct from her husband. She had the same legal standing as a child, an idiot, a lunatic, or a slave. Now, there was one limitation, which was what's called dower rights. Under English law, the wife had a right to 1/3 of the value of the real estate held by the couple, not the property. So for example, in the South, slaves were property. She had no rights there. But those 17,500 acres, she retained a right, Martha Custis retained a right to 1/3 of their value. So in states such as Virginia, the court would appoint 2 upstanding men of the location to take the woman aside if the husband wanted to sell property and ascertain her willingness to have the property sold. And then that was reported back to the court where it was recorded. If they didn't do that, she had the right to go back and demand, literally demand the property back because it had been invalidly sold. However, it was a little different in New England. New England, unlike the South, was not particularly into the idea of British law, and it didn't match their Puritan beliefs. Under Puritan belief, the husband was the religious head of the family and made all decisions. A quote from an early Puritan leader: "The woman was made for the man's comfort, but the man was not made for the woman's command." Ooh. So they did not have any of those dower rights. And then there were the Quakers, and this is what happened in Pennsylvania. The Quaker religion allowed women to speak freely, but it was the wife's duty to defer to her husband in all marital matters. Therefore, it was, according to their religion, it was impossible to imagine that the wife would disagree with the decision of the husband to sell property. Okay, that was his decision. So we get to common law marriage and divorce. This is a graph of marriage and divorce starting about 1860. I can assure you that the graph prior to 1860 for divorce is even less. You really did not get divorces in the early part of our country. So you get interesting examples. This is Rachel Donaldson and Andrew Jackson. Rachel married a Captain Lewis Roberts. He abused her and they agreed to a divorce. She then a few years later married Jackson in Natchez, Mississippi. Oops, he had not completed the work to get the divorce approved, because at that time, to get the divorce approved, he had to have legislative approval. Literally, the legislature had to approve the dissolving of the marriage. They remarried in 1794 after the divorce was technically done. But the result of that was that she was always accused of bigamy, and at least one of Jackson's famous duels was with a man who in fact had accused her of being a bigamist, and all the necessary other words you might imagine with that. Which then takes us to Benjamin Franklin and Deborah Reed. Franklin proposed to Deborah Reed when she was 15. Her family rejected him, and he promptly went off to England, where he was, or France, I forget which now, where he was representing some of the colonies, made his name, came back. Okay, and in the meantime, she had married John Rogers. He then Rogers abandoned her. So in 1730, Franklin entered into a lifelong common law marriage with Reed. And it had to be common law because in the absence of her first husband, she could not get a divorce. There was no mechanism in place that would let it happen. So that brings us to common law marriage. Common law marriage is unlicensed, an agreement to be married. This is the mutual consent, cohabitation, and public representation of marriage. Frontier marriages were often common law. I mean, a real marriage cost money, and the ministers were not that available in a lot of cases. In Virginia, the only recognized ministers were those of the Episcopal Church. And if you were a Baptist living on the frontier land of Virginia, you never saw Episcopal Church minister, much less, so you heck with it. All colonies and states recognized common law marriages. Self-divorce and remarriage was actually very common, as long as the prior spouse did not challenge the idea. 14 states today still recognize common law marriages as being legitimate in the divorce. Divorce was very uncommon. True divorce was very rare in the South. It was more common in New England, but there was no, true divorce was easier in the Puritan states, but separations were not. The woman had no separate rights. This is a famous cartoon from the middle of the 19th century. For those who can't read it, John, where is the rest of your wages? The wife. John, where is the rest of your wages? How am I going to pay the landlord? Where's food for the children? Husband, shut up. What I do with my money is my own business. If a woman went out and worked, the money she earned would go to her husband, who would decide what to do with it, even in a case like this. And there's a famous case where Abigail Smith married Asa Bailey and had 14 children by him. He then promptly went off to Ohio to determine whether he could live there, and took some of his children. And on the trip, he sexually abused their oldest daughter. When Abigail learned of this, they became enemies. Sort of makes sense. In 1792, he proposed that they sell their property in New Hampshire and move to Ohio. And he had a buyer in New York, he said. So he took his wife to New York to meet the buyer, where he abandoned her as he went back to New Hampshire to complete the sale before anybody caught up with him. She made her way back. Wonderful long story about how. Found a justice of the peace and had a writ issued against him. At that point, he took all the children to Ohio because that was his right. As the husband, he had a right automatically to all the children. She then threatened to bring a suit against him for incest, which was a capital crime in New Hampshire. He said, okay, we'll do a deal. I'll take the 3 oldest boys, you keep the rest of the family. So self-divorce was common if there was no legal complaint. Courts recognized a marriage as legitimate that was actually bigamous. And bigamy was generally seen as better than a legal divorce. So that's sort of the history of where we were prior to the American Civil War. And after the Civil War, very gradually, the states began to open up the rights of women. But even well into the 20th century, there were many vestigial laws that were still on the books that supported the right of the man against that of his wife. So now we'll shift to the 20th century. In our lifetimes, what have been the big impact items? And it's sometimes hard to remember how many of these items were not in place when we were young. First birth control pill. Miscegenation was not ruled unconstitutional until 1967. No-fault divorce first came in California in 1969. Spousal race was universally a crime by 1993. And of course, same-sex marriage was constitutional in 2013. So, since we're talking about the 20th century, this is viewed by almost everyone as the most famous marriage worldwide in the 20th century. Okay? Diana and Charles. So, question number 2 for the homework assignment is, what was the most famous marriage in America in the 20th century? I would suspect people will get more people will get this one. So, the first thing is, during much of our lifetimes, much of the country's lifetimes, there were religious prohibitions on marriage outside your religion. So one is the Jewish religion, where many Orthodox rabbis consider that you cannot marry outside the Orthodox Jewish religion. This is a poster from the mid-19th century about mixed marriages, but a Catholic archbishop who basically said, you can't marry outside the Catholic Church, okay, or you will be excommunicated. That's what the word mixed meant. And with slaves, slaves weren't allowed to marry. So they developed what's called jumping the broom, where the community of slaves would get together and there would be a broomstick held out and the couple would jump over it, and that would represent the crossing the altar, and now within the community they were recognized as married. Miscegenation. This is John Rolfe and Pocahontas. Clearly they were of different races. They were allowed to marry. But within 50 years, in most of the states of the country, a white male could not marry an Indian. And by the way, the reverse was almost always never allowed. This is an interesting couple. Helen Emery was the daughter of John Emery, the Archbishop of San Francisco's Episcopal Diocese. Race Cathedral? Think about that. Okay. Gunjiro Aoki was from a very high-ranking samurai family in Japan who had converted to become an Episcopal and came to this country to study under Emery so he could go back as a minister. And, well, they fell in love. Helen was the daughter, and they decided to marry. Oops. Couldn't get a marriage license in San Francisco. So they literally took a series of trains north, and this was reported widely in the press at the time. Series of trains north, and at each major city stop, they would see if they could get a license. The answer was no, until they got to Seattle, where they were finally able to get a license. 1909. For those who have followed previous discussions on this topic, she lost her citizenship the day she married him, because the whole problem in American views was that citizenship went with the husband. So a foreign woman who married an American citizen male would become a citizen. That made sense. But an American woman who married a foreign male, nope. Well, in 1922, they reversed that, except for women who had married Asians, because Asian immigrants never could become citizens. That had been the rule. So he had no hope of being a citizen, therefore she shouldn't be. 1932, he died, and she got her citizenship back. We more commonly think of mixed marriages between blacks and whites. Or the classic relationship is that of Thomas Jefferson with Sally Hemings, okay, which has now been proved with DNA beyond doubt. Is that me? What? Okay. So by 1900, we have James Johnson and his wife, Etta Terry Duryea, in New York. So it was recognized that you could have mixed marriages. Johnson was a successful boxer and entertainer, and so you can think of that as falling almost into the entertainment world. But the key to miscegenation was when Mildred and Richard Loving fought the laws of Virginia and won in the Supreme Court in 1967. The Lovings had met in high school in Virginia, had gone to Washington, D.C., where they could get married. They did. Went back to Virginia, where they were promptly sentenced to a year in prison for having illegal fornication, okay, which is the typical felony you were accused of if you were a mixed marriage. They were sentenced to a year in jail, which was suspended if they agreed to leave the state and never come back. So they went to District of Columbia, and then they said, this is ridiculous, and they started a 10-year lawsuit that it is the Supreme Court. Virginia said that the idea of equality didn't apply because the penalty was the same for the people of both races. Okay? In other words, he had the same penalty she did. He was white, she was black. Or he was, so. All right, which moves us now to Sarah Orne Jewett and Ann Adams Fields. These were two successful authors who in the 1880s were in what was called a Boston marriage. In that period in New England, you had a common thing where two successful women would live together, maybe or maybe not romantically. That's not a factoid here. Indeed, in the late 19th century, there were 53 female instructors at Wellesley College. One had a male husband. The others all lived with other women. But where that may not have been a start of the gay revolution, these were. Nina and Genora tried to get married in Hawaii, and they got the obvious answer, no. And that began the 23 years that ended with 2013, the decision that the Supreme Court made that gay marriage was legal. Now, test questions. Who wants to try the most famous marriage in America in the 19th century? Say it. 19th century. I know she's old. She's not that old. Right. The short answer, whoops, I blew it. Moved ahead. It was Tom Thumb and Lavinia Warren. P.T. Barnum sold 5,000 tickets to their marriage in 1863 in New York at what today would be a value of around $2 million. Okay. So you can think it was just like it is today. I mean, a lot of what happens has to do with the people who are in the entertainment business and have all the publicity. Okay, I've already told you the answer on the other one, which is in the 20th century, it's clearly Jack and Jackie. That's an easy one. Okay. Thank you for hanging in there with me, and I would be glad to take questions and do the best I can.
Do you have any questions?
Okay.
Congratulations on a fantastic talk. Thank you.
Thank you, man.
I would like to know a little bit more about what happened. What was the process of changing the property rights that women, in other words, women's legal rights under marriage? When did that begin to get more reasonable?
After the Civil War.
And what,
And it was state by state. Various states would, it's no difference, for example, than it happened with women's suffrage, where I think it was Wyoming was the first state that opened up. Okay, but state by state, they would gradually come to grips with the fact that they couldn't handle it. One of the most important ones actually was the issue of the rights of children. Up until the Civil War, if you were going through a separation or divorce, the children automatically went with the husband if he wanted them. The idea of what are the rights of the children, what's best for the children, did not appear into the law until the latter part of the century. But that's typical. There was a lot of social things that were going on at that time. Oh, sure.
I just wanted to mention one other thing. In Nepal, the traditional law was that if a man wanted to get out of a rape charge, he could do so by marrying the woman. And this made everything fine.
Okay. Any questions on Zoom?
I have a question, George. If the man controlled all the money and she, even if she worked, it wasn't her money, did some of the women, were they very poor if their husbands abandoned them? I mean, what did they do? What
Yes.
options did a woman have to support herself and her children?
The answer is not many. That abandonment in this period was not at all good for women. I mean, the reason it worked, three things. One, it was the system everybody was used to. So you sort of grew up knowing that's how it would be. Secondly, most women had brothers and fathers and uncles, okay, who would, let us say, make sure that things worked out better, okay? And the third one was most men did not abuse their rights. It's like Washington. I mean, he could have sold off all the slaves if he wanted to. That was perfectly within his rights. But his position was, I'm the fiduciary, I'm responsible for my stepchildren, and I will take care of them. But and the community, almost always. Remember, we're talking rural communities, and you know how tight a rural community can be. One other point, for much of this period, going up to Civil War, if you got married, you often needed to have some sort of certification that the marriage was legitimate, filed with the state. And the reason was because if you turned out it wasn't, the community would turn out to have a responsibility for the woman and the children. Okay? So the community didn't want that, so it wanted to say, who's going to take care of these people if there's a problem? Okay, other questions?
Any other questions on Zoom? Great. Thank you, George.
Thank you.
For a great talk. I want to invite you to join us next week when we have Dr. John Friedman on gene editing and extraterrestrial colonization. There's a big one for you.